Be seated, please. Although we had quite a number of cases originally scheduled, we now only have 2 cases scheduled for oral argument today. The first is Insurance Company of the Americas versus Department of Financial Services. Is counsel for the appellant ready to proceed in the first case?
Yes.
All right, if you'll come forward.
Your Honor, at this time, I'd like to reserve 5 minutes for rebuttal.
All right, I'll help you keep an eye on that.
Can you hear me okay, or should I raise the podium?
I can hear you fine.
All right. May it please the Court? My name is Alan Leifer with the insurance law firm, and I'm here today representing the Insurance Company of the Americas. 444 days ago, nearly 15 months, the Florida Office of Insurance Regulation issued a declaration finding my client to be financially insolvent and to have violated numerous provisions of Florida law. Since that time, nearly 15 months ago, there has been no subsequent determination or declaration contrary to what was stated 15 months ago. We're here today because of 2 reversible errors by the Office of Insurance Regulation. First is the Office of Insurance Regulation's brand new interpretation of the Florida Insurance Code, providing that a statutory financial examination does not provide for a point of entry and is not final agency action. Quite simply, as quoted by the General Counsel and agency clerk, we don't do that anymore. The second reversible error is the OIR's failure to acknowledge the sufficiency of the appellant's petition, amended petition for formal administrative hearing. Now, a financial statutory examination is a statutorily mandated periodic examination of the accounts, affairs, transactions, records, and assets of an insurance company. Pursuant to Section 624.316, that examination shall occur not less than once every 3 years. The examination in this case covered the time frame of January 1st, 2003 through December 31st, 2003.
Does the consent order that was entered after the recommendatory order cover this same period of time?
The consent order that was executed by the parties specifically covers this period of time and specifically covers the findings of the 2003 statutory financial examination report.
And why doesn't it then supersede this recommendatory order and conclude the matter? And was it appealed?
The Insurance Company of the Americas sought due process, a point of entry relative to the financial examination report. That report was executed or entered June 30th, 2005. The consent order that was executed did not occur until November 2005. So if the parties had waited and executed the consent order, not preserved their point of entry, it would have been waived.
But the consent order concludes everything.
No,
I mean, were we to find differently in this case, it would go back and you would have already agreed to everything? What happens to the consent order?
Well, the consent order left untouched the findings and conclusions of the statutory examination, and there was specific language added within the consent order.
Incorporating by reference the recommendatory order, did it?
No, the statutory financial examination was the entire basis of the consent order.
Right.
The waiver language was amended in the consent order to specifically exclude this pending action because through today, the Insurance Company of the Americas disputes the findings of fact and conclusions of law of that statutory report. The company had essentially no choice but to execute that consent order.
But whether you dispute them or not, isn't it irrelevant? I mean, if you got a consent order going on, why isn't the case moved, regardless of what you thought about it back then?
Because the findings of fact and conclusions of law of the statutory examination are very serious, and they have a lot of implications for both the company and the officers and directors of the company. And to let those findings stand would be a gross injustice, and lack of due process would be significant, and I'll explain why. There are several statutes
Well,
that
let me
are-
ask you one question before you get there, and that is, the order from which you appeal, recommendatory order, is not enforceable, correct?
the recommended
There's
order.
nothing to enforce. I mean, there's no penalty, it's just these findings that they've made with regard to the company. This is not what you would call an enforceable order. My concern is with the finality of the order, of what exactly this recommendatory order is.
Well, let me clarify first. It's not a recommended order. It's a statutory financial examination. There is no order.
No, I understand, but
was avoided.
they're saying, the department, I believe, is saying, that what's contained in this order is merely recommendatory and is not anything that they would enforce, or that anything they've said in there. There's no fine being imposed. This is just recommendations, so to speak.
Well, it actually goes a little further beyond that, because based upon the conclusions within that document, the Insurance Company of America has no choice but to comply or to come into compliance in accordance with those terms.
Which by the consent order they agreed to do.
By the consent order, the company agreed to increase the finances of the company in an effort to avoid the involuntary liquidation or rehabilitation of this company. Now, I want to go back to a point before you ask this question. There's a couple of statutes that are very relevant when it comes to an insolvency. The first that I think...
Before you get into that, you were mentioning earlier that counsel for the department indicated we don't do that anymore, basically, and I think what you're referring to is we don't provide a point of entry anymore after this statutory financial examination report is issued.
That's correct.
And that point of entry had been provided earlier.
No, it had not.
But I'm not talking about in this case. I mean, in the past,
Oh, yes,
a point of entry had been provided. The lawyer was saying we don't do that anymore.
Correct.
And I wanted to be certain that I understand why that is the case. Now, my understanding is that in the past, fines had been assessed in these statutory financial examination reports, or at least there were requirements for affirmative action by insurers that were included within these financial examination reports. But the view of the department was that was no longer necessary because they weren't requiring the insurers to do anything. Is that a correct understanding of the department's position from your perspective?
That is one of the arguments that the department has made, that the order contains only recommendations. However, those recommendations, if the company were not to follow those recommendations, the existence of the company is jeopardized through involuntary rehabilitation and liquidation.
Well, why didn't the insurer have a point of entry in connection with the assessment of the fine?
Because the way that the fine was presented to the insurance company was through a consent order. The consent order was presented and said, you will sign this, and the consent order waives challenging any of the terms of the consent order.
I thought that there was a cover letter that went out with the insurance company's copy of the statutory financial examination report that indicated that the fine was being assessed.
That's correct. In page 99 of the record, the cover letter to the final exam report, it specifically states in the last paragraph that it is the office's intention to impose a penalty of $100,000.
Oh, but that's only saying intention. That's not the actual imposition of the fine. What you're saying is it wasn't until the consent order that there became the imposition of the fine because the parties signed a consent order.
Correct.
Agreement.
It wasn't until the consent order until a penalty was paid.
Which was the agreement to have that penalty imposed, in a sense, by the way of a consent order.
The company had no choice. The company had no free will on this. We had to pay this. In order to live to fight for another day, the company really had no choice.
But what do we do with the consent order?
Did the
consent order get appealed on the basis that it was under duress, or I don't know how you would appeal that, but...
No, I don't think the consent order can be appealed because because Insurance Company of America waived its right to appeal the consent order, but it preserved its right to bring this action, which was pending at the time the consent order was executed. As a matter of fact, the notice of appeal had been filed in this case prior to the execution of that consent order, so this case was out there. Now, I want to talk about this insolvency because it's significant. Section 624.319, subparagraph 2, provides that this report is admissible in any proceeding brought by the the Office of Insurance Regulation against the Insurance Company of America, its officers, or its directors. Now, this is very significant because if you continue into the insurance code and you look at Section 631.051, I'm going to talk about rehab and liquidation. Grounds for rehab: the department may petition if it finds the insurer is insolvent. So you're subject to that remedy by the department. Liquidation: the department may apply to the court for an order of liquidation if the company is or is about to become insolvent. We already have a declaration of insolvency. Very important, the Unfair and Deceptive Trade Practices Statute, 626.9541, makes it a third-degree felony for an officer or director of an insurance company to solicit, renew, or write insurance when it is considered insolvent. So now the directors and the officers are subject to a third-degree felony, 5 years imprisonment, and $5,000 fine. Most importantly, from the perspective of the company and the management, is Section 624.4073. And this section provides that a director and an officer of an insolvent company will be barred from serving as a director and an officer for any insurer in this state. So those statutory provisions are kicked in and become an available remedy for the Office of Insurance Regulation based upon that finding of insolvency. So the company has no choice but to seek its due process, to challenge that finding of insolvency, and to this day the company believes that it is not insolvent, has never been insolvent, and that a hearing with testimony by actuaries and experts and the company and the Office of Insurance Regulation will demonstrate that the company was not insolvent.
None of those concerns you just listed are still present because of the consent order.
Yes, they are.
Why is that?
Because the consent order, both the statutory examination said the company is insolvent, and the consent order said the company is insolvent. Now, there was the company did put in additional capital, but the findings of insolvency are still there. And what's very important from the perspective of this company is that today, ongoing, is a new examination, and a new report will be issued.
Right. You're having a new examination, but the company is still operational, right?
Thankfully, yes, the company is still
Right. And
operational.
so the officers and directors are not concerned about committing a crime at the present moment, are they?
It has not entered their thinking at this point because of this pending action. But
Well, is it because of the pending action, or is it because of the consent order?
well, because of the consent order and the statutory report, the findings of insolvency.
I would expect that the consent order has resolved the operational, ongoing concerns of the company, between the company and the department at the present time. Is that
No,
not right?
I don't think so, because the consent order adopts all the findings and conclusions of the statutory report, so it adopts the insolvency of the company. And the issue is that new examination, because the new examination will come out and it will cover 2004 through June 30th, 2006. So if the interpretation that was applied to the statutory financial examination in 03 is consistently applied, this is the determination of surplus, is consistently applied, then it's very likely that there will be another finding of insolvency.
You're into your rebuttal time.
Thank you very much.
Yes, sir. We'll reserve the balance of your time.
Good morning. May it please the Court. Susan Dawson on behalf of the Office of Insurance Regulation. I'd like to follow up before I begin with some comments as to Judge Davis. You did make a comment regarding that basically the consent order concludes everything, and you are correct in that. In fact, the office filed a motion to dismiss this suit based upon mootness. Essentially, the consent order is a collection of corrective action that the company has already agreed to do in order to address the findings and the recommendations in the report.
Why did the department oppose the placing of the consent order in the record when the opposing counsel requested that it be included?
We were following the rules, and the rules of court, if you read them, the plain language of the rules do not allow for the consent order to be entered into the record. However, it was attached to the motion to dismiss because the consent order was entered into in November, and the amended petition, the order denying the amended petition, was entered in August. So it was not included within the definition of the record pursuant to the rules of court. So, although it would have benefited us, we did not want to take advantage of the rules. So.
Ms. Dawson, what we have here, as I understand it, is we have findings by the Department of Insolvency by this insurance company.
Your Honor, I would not agree with that. If you look at the record, there are not specific findings of insolvency. There are some serious issues with the company and the financial status of the company. But if you look at the last page, and I'm looking on the record at page 135 of the record, it's the last page of the exam report. Our examiner is basically stating, and I'll quote, per examination findings, the company's surplus as regards policyholders was a negative $1.3 million and change, which was not in compliance with 624408 and places the company in an insolvent financial position. And then it goes on, it is recommended such and such. We're not saying, point blank the company is insolvent.
Well, you are saying, though, that there are substantial questions about the financial security of the company.
That's correct.
All right. Well, that's a finding by the department, then, that there's substantial questions about the financial security of the company. Now, as I further understand, based on those findings, this insurance company has been required to put up some additional money.
Required as a result of the consent order that was issued.
I understand that, but if they disagreed with the findings as to the question of the financial security of the company and felt that it was not necessary to put up the additional funds in order for the company to be sufficiently secure to satisfy the requirements of state law, they obviously are adversely affected when they pay this money and they think they should not have to pay. So my question is, where was their point of entry to challenge that in a formal proceeding?
There were several points of entry, and I think the key here for the panel to consider is whether or not the substantial interests have been affected and whether or not that was pled appropriately. If you review the petition, the amended petition filed, as well as the original petition filed by the company, they failed to adequately describe what their substantial interests are.
Well, I understand that, but all you're talking about there is the point in time at which this statutory financial examination report was issued. I mean, after that, they had to put up some money. And my question is, between the time these findings were made, I guess your position is that at some point between the time these findings were made and the point that that the insurance company didn't agree with, and the point in time at which they had to put up some additional money, what was their point of entry to challenge this in a formal proceeding? I mean, they're obviously adversely affected if they have to put up a big chunk of money to satisfy the department.
The time frame, Your Honor, is key here. In June, when the exam report was issued, it was issued subsequent to an informal conference. So there, you had a point of entry, not into 120, but you had an informal conference regarding the exam reports. After the exam report was filed and placed on our website, subsequent to June 30th, the company had a point of entry with regard to filing their petition for formal administrative hearing, which they did. And we responded to that and found that it was deficient. It did not meet the requirements of the uniform rules. It did not was not in substantial compliance with the rules, did not spell out what their substantial interests were, and so that was denied.
So basically your position was that the financial statutory report did not provide a point of entry.
The financial exam report in and of itself, because it only has recommendations, there's no fine associated with it, there's no penalty, there's no sanction, does not provide a point of entry.
Okay,
however,
so
we do have a rule.
But that's basically what the department found at that point when they said this petition for a formal hearing was not sufficient. They were saying, look, you're not substantially affected by this. This is just a report. It's not even a requirement. There's some suggestions here, but it's like a preliminary sort of thing, so you don't have a point of entry here. And I guess what I'm coming back to again is, did they ever get one? And if they did, at what point did they have a real point of entry for a formal hearing?
In this particular case, it does not appear that that would be the situation because the way the exam report is written. If we were to produce an exam report for, say, some other company, or in their next exam report that has specific sanctions in it, a fine attached to it, then that would trigger the 120
I'm not
point
talking
of
about the
entry.
examination report. I understand the department's position on that. That doesn't provide a point of entry. Gotcha. Okay.
Okay.
What I'm asking is that based on the findings in this examination report, this insurance company was required, I don't know how much, but I guess a lot of money they were required to put up to satisfy the department as to their financial security.
Was that?
And what I'd like to know, and I'm not going to ask you again because I really just want to know, was there ever a point between the time these findings were made and the time the company was required to put this money up where they had a point of entry to challenge this in a formal 12057 hearing?
I would say yes.
Okay, where? When?
The point at which they filed their petition for formal administrative hearing.
Okay, but then I have a follow-up question to that, and that is
Yes.
this. Were they required to put that up before the consent order was entered, or was that all part of the consent order?
It was part of the consent order, Your Honor.
So the first order, I mean, insofar as time sequence, you have your exam report in June, and then time passes, and the money's not put up, they come to the consent order. That is what requires the money to be put up and the fine to be paid?
Yes, Your Honor.
Until that time, there was no requirement that those events occur.
There was no
Is that
requirement
correct?
that they do anything between the end of June and November
It was a
when the
consent
consent
report.
order.
It was a
During that
consent order.
entire period, those several months, we were in negotiations with the company. We went through several drafts of the consent order, and the company did file their notice of appeal, appealing the denial of the petitions for formal administrative
What
hearing.
if they hadn't entered into the consent order?
I'm sorry?
If they hadn't entered into the consent order, none of these requirements would have been enforceable at that time? What would their
Well,
relief have
it
been?
depends on the current status of the company at that time. We did decide to go through another exam to bring it up to time, because the current exam report was basically 2 years behind, so to speak. So I know counsel has alluded to the fact that we would have invoked 631, which is a rehab and liquidation statute, and recommended to the Department of Financial Services, because we are the Office of Insurance Regulation, recommended to DFS, which has authority under 631, that some action would have been taken. We do not have the authority under the statutes to put a company into liquidation or rehabilitation. That is something that the Department of Financial Services does, not the Office of Insurance Regulation.
So if the department, if the insurance company had not entered into the consent order, the department would have recommended liquidation proceedings be initiated.
I can't say that for sure. That's a decision that's made by our examiners working with our insurance commissioner.
Well, your opposing counsel has indicated that the company had no option. I mean, they had no alternative. They had to enter into the consent order. What do you have to say about that?
I think that is certainly not true. For a company, for a representative of a company to come up here and say that they had no free will is absolutely ridiculous, and I hope that the panel does not go down that route, because certainly that's not how we do business at the Office of Insurance Regulation.
Well, isn't it certainly true that they had to provide additional surplus in order to continue operating under the department's view if they were going to not be held insolvent by the department?
As a result of the consent order, which they've negotiated.
As a result of this
Yes.
report. This report finds, I don't understand how you say that this paragraph says that it's not a finding that they're insolvent. It specifically says it places the company in an insolvent financial position. I don't see how you could get it any more clear than that. Once the department makes that finding, isn't the company insolvent as a matter of Florida law?
If it was insolvent at that particular time, we would have made a recommendation to the Department of Financial Services in order to have them take any sort of action if necessary. But that was not done. And the reason for that was this report ended as of December of 2003. We were in 2005 concluding this. So we would have had a tough hurdle to try to push a company or, recommend some sort of action, rehabilitation or liquidation of a company with a 2-year gap
Well, let me get
in
you
circumstances. So really this exam report, excuse me, Your Honor, is a snapshot of the company's...
I understand that. Let me get you to Judge Allen's question, which is, where's the point of entry? Doesn't the administrative rules of the Department of Insurance specifically provide, in this instance, a point of entry? It says in 69N-121.066, subsection 2,
Yes.
procedures for conferences held pursuant to section 624-319, sub 1. And in that sub 2E, it seems to me provides specifically exactly the point of entry for this circumstance, but wasn't complied with the department. Why is that?
It does provide a point of entry, and I did answer Judge Allen's question in the affirmative to that. But notice, I have my copy of it over there, but I basically know it. Notice that there's language at the tail end of 2E, which basically states, in accordance with Chapter 120. And if you look at 120.57, because you have disputed issues of material fact, you still must have substantial interest affected. That paragraph, that rule does not guarantee that you get a hearing at DOA.
Well, one of the things, I know you say that there is not sufficient allegations. One of their allegations is their ability to transact business in Florida in accordance with the Florida Insurance Code. If they're insolvent, they're not going to be allowed by the department just to continue to operate in an insolvent position, are they?
But they're speculative.
I'm sorry?
I'm sorry, they're speculative.
It's speculative as to whether they're insolvent or not?
No, whether or not we will forward the issue or the matter to the Department of Financial Services.
Well,
that was not done.
Is the department's practice in the state of Florida to permit insurance companies to operate in an insolvent position?
Certainly not.
Okay. Well, how is that speculative then?
It's speculative in terms of this particular case. As I said, this was an exam report that was not brought up to date. It was dated 2003. It's a snapshot of the company as of 2003. In 2005, when the exam report was finished, you're looking at a 2-year period, and it would be almost foolish for the Department of Financial Services, not OIR, but for DFS to go into court, in circuit court, and say, the company is insolvent. I can just imagine the circuit court judge saying, well, wait a minute. What about 2004? Has the company's standing improved? What about this tail end of 2005? So we would need to bring more information to the table, which is why this exam report does not impose any penalties. It does not impose any sanctions. It does not require them to do anything in the black letter of the exam report. It is simply a snapshot of the company's financial condition as of December 2003. And yes, they needed to make some changes, but we also, as an agency and as our examiners, needed to go in and bring the report up to date, which is what they're doing now. As we speak, they're examining this company. And they're under the consent order as well to do various things to bring it up to par. And the consent order is a part of this court's record because it was filed as an attachment to my motion to dismiss. If the court has no further questions, I'll rely on the brief.
Thank you, Ms. Dawson.
Thank you.
May it please the Court, I want to make a very important point here, and it concerns the current financial examination. The OIR has stated that the numbers were too stale. The 2003 numbers were too stale to go into a court and seek rehabilitation. The new exam report is going to be through the period of 9/30/05. And if this procedure is not corrected, if these errors are not reversed with the 2003 financial examination report, it's very likely the company will be brought into receivership, or there will be a move using the findings of insolvency based upon the rationale of calculating the surplus that was used in the 03 report, which we don't know what that is, because the 03 report is conclusory. It does not give a analysis or a rationale of how these numbers were reached.
Well, in an informal conference transcript, there was a rather detailed discussion between your actuaries and the department's folks about how those numbers went in there, right?
It was not detailed enough to make a determination as to how the actuary came to his conclusions. The actuary referred to something called a block and tackle approach, and we're not familiar with that. Now, I want to raise another point here, and that is the point of entry. There was no point of entry in this case. If you look at the rule for informal conferences, and treat an informal conference as a mediation, but 121.066 provides, sub 2E, does provide for a point of entry. It also provides for the service of a notice of rights. There was no notice of rights in this petition, in the exam report. There was no notice of rights in compliance with 121.066. So that did not happen here.
Explain to me why your company had no option except to sign the consent order.
Because at any time, the company could have been brought into administrative supervision, where the OIR comes in and manages the affairs. It could have been brought into rehabilitation or liquidation based upon this report, and there would be no defense.
So failing to sign the consent order was risky.
It was very, very risky. Not only that, but you also have the loss of business due to this publication of insolvency on the Internet. I see my time is concluded.
But you always have time to answer questions.
Absolutely.
But if you'd refused, and one of these adverse actions had been taken, then clearly you would have had a point of entry then. I think you'd agree.
You would have had a point of entry at that point to challenge the insolvency, but that point of entry was too remote and distant in order to challenge the findings of the statutory report. The statutory report, without seeking a point of entry by ICA, would have been done and final and no option to challenge it whatsoever.
Okay, thank you.
Thank you very much.